Okay, this is the first of two parts for what would be Chapter 4. This is dealing with amendments and civil liberties that we have. We started amendments our very first 2 weeks. We come back and we finish up with both civil liberties and civil rights to end the year. I have this as the title for your First Amendment rights, but this includes more than just the First Amendment rights here, but that's what we're focusing on this section. The second part will focus more on amendments 10 and through 9 in that case there. So, first of all, what are civil liberties? A repeat AP question is to make sure that you know what the difference is between civil liberties and civil rights. When you see liberties, you should be thinking of freedoms. But civil liberties are your individual ones. So this is where you individually, and notice against government actions, is protecting you against that. Civil rights is for groups of people. And that's what we'll cover for the Chapter 5 and a lot of our court cases that we did here. And you'll notice a lot of the court cases from our court case projects are going to be in this, as well as others. So there are some of those 36 that you do need to know straight out. As you did before, there are 27 amendments. The first 10 are the Bill of Rights. The first 9 deal with individual rights. The 10th Amendment deals with states' rights. 11 through 27, most of that is dealing with the expansion of democracy there. Other than that, they are usually more of just formalities that need to be done. For about the 5th time this year, who is the final interpreter of our liberties? This is where it ultimately comes to the federal courts and ultimately to the U.S. Supreme Court. Several things here for the federalism here. This is where we will have, and you think of with the Bill of Rights where they were added, we had the anti-federalists that had written and said there was not enough protection of these liberties, too much power by the federal government there. The Federalists didn't think it was needed, but this is where we work to have this. Over time, we have had a lot more expansion of the Bill of Rights with the Selective Incorporation. We're going to come back to that again. Here, but our whole federalism unit that we had. And this is where our first incorporated case was Getlau, when it has to do with speech in there, but it is saying that the states have to. We have had it come up in the recent years where different ideas that the states must incorporate. In the beginning of our country, where we had our dual federalism, it wasn't that the way. There was this separation, and Barron versus Baltimore, the Slaughterhouse cases, restrained the power of the national government. But after Getlau, the 14th Amendment, the Due Process Clause, will have it. There's a table in your book on page 89 that shows a lot of this. Although we usually think of our liberties in the Bill of Rights, there was already several that were in the Constitution straight out. This goes back to when we were in September, and you remember where we had the Constitution and those that were already in it automatically. The writ of habeas corpus, the no bills of attainder, ex post facto, all of those things were originally in the Constitution. When we look at some things, we say that we maybe didn't need to have the 6th and 7th Amendment with the idea that you have for bills of attainder and writ of habeas corpus, but that gave more so for those things. Ex post facto, punishment for a crime before it was actually illegal. There, if you did it, gets already in the Constitution. For our interest groups, you've noticed a lot of the cases we've had the American Civil Liberties Union. This is an interest group that fights for civil liberties, and this is where when you see this, I mean, normally if it's something you believe in, you love what the ACL is doing, but then you look at things that you maybe don't believe in. Sometimes you think they're going too extreme there, and that's usually what ends up happening with people here. Once again, with Selective Incorporation, this is where it expanded, and the idea using the 14th Amendment. Boy, I've said that a lot of times. But the 14th Amendment and the Due Process Clause made it where the Bill of Rights was not just national. The states had to apply it. The Getlau case was the very first one with freedom of speech, and our most recent one was in 2019, dealing with excessive fines of the 8th Amendment. In this case, it was a Midwestern state where a person that was caught with a small amount of drugs, but then his car was impounded. The car was sold, and it was something that he had, I believe, had inherited or something. So, and it was worth quite a bit of money. I believe it was like a $50,000 Range Rover or something. And by the time he got everything cleared, it ended up that they had already sold the car with it, and a lot of local small governments were using that as revenue. So was a $50,000 fine too excessive? The Supreme Court said yes there, so they were abusing with that law. All right, our First Amendment that will be focused the rest on this. There are 5 parts. You need to know all 5 parts. And with some of those parts, there's multiple parts you have to know and separate it here. Speech, press, assembly, religion, and petition. There's an old saying, St. Peter ate rice pudding, that some people have to remember that. I don't. I just straight out have to memorize the 5. But that's where you need to know it. First one we're going to focus on is freedom of speech. There's 2 different parts you need to know. Pure speech and then symbolic speech. And pure speech is given a lot of protection in the courts. And this is where we'll even look. What is seen as despicable speech is even protected. What you might get railed on in social media may not be actually illegal, even though it may not be seen as what is right. Historically, different regulations of speech that we had, going back to the old Federalist and Democratic Republican Party when the Sedition Acts of 1789 were passed there. The Sedition Act of 1918 will be passed in the time of the war, which this is where the Schnitt case will come about. And they will have the clear and present danger doctrine and the idea that yes, you can have some regulations on your freedom of speech. It's not always something that you have. But it wasn't very well defined. Brandenburg versus Ohio, which was not one of our 36 cases, but one that you should be familiar with, will make it where it's less restrictive and give more ideas. Key things you need to know for regulation of speech is fighting words, or is it a direct incitement here. So you can go and give a speech. If let's say the KKK is giving a speech about how there are superior races to others, that is actually legal. But if you are to go and say, we're going to go and burn down this black neighborhood, and you're inciting violence in that way, that is not in the freedom of speech. So again, those fighting words idea that you have. Symbolic speech. 2 of the cases that we had and went over with Tinker and Johnson are example of this. The armbands and Tinker, the flag burning. Both of those, the Supreme Court said that they are symbolic speech there. And symbolic speech is protected also here. Other speech cases you need to know, mentioned several different times with incorporation, where get loud was the very first one, and that will be the start of it. For the obscenity side, the one that we focused on in our court cases was Miller, where it set different standards there, basing some of the standards that if something is seen as where it is not artistic, scientific merit that you have. The one thing I say, what is the most important element? A lot of this comes down to community standards. That is why here in Citrus County we do not have strip bars, but in Tampa they do, because there's different standards of what is seen as obscene in Citrus County compared to Hillsborough County. The Roth case, this is where it was said that obscenity is not protected by is not protected speech. There can be some limitations to it. Miller will build upon that. Reno versus ACLU is one you need to be familiar with, and it basically said a lot of things for the internet rules. And what it pretty much said is it's the Wild West. There's only a few things. The most obvious that can be regulated on this is child pornography. Some of it may have been far-reaching, and then realizing that it would be hard unless you're doing true censorship of things. This in recent months has come under a lot of conflict in where it's actually more conservatives that are saying that, well, these private companies doing their own censorship, and there maybe needs to be something more national with this. One topic that we have had multiple times, and this is where your 2 cases we went over with Buckley and Citizens United, were cases that money is seen as speech today, where in Buckley an individual candidate cannot be limited to how much they have, and then Citizens United in 2010 will take that a lot more for corporations and unions there. But money is an example of freedom of speech there, and should you be limited, and even if you are a corporation, which is a legal entity. Some of the different topics, and some of these are in your textbook, in your chapter you're reading, but whether you're being compelled to speak against your will. So I'm in a teachers union, and even though I definitely do not agree with a lot of things that the National Education Association has, some of my dues go to candidates that I don't support there. So am I being forced to speak against my will in that case of this? Some of the things that was kind of pointed out in here, Justice Kagan had said that with the Citizens United case, we're weaponizing the First Amendment with using for the money. kind of with same with unions, where some places were being forced. This kind of goes in the same way that this is why some areas were saying, I actually don't have to be in part of the teachers union, but in some states that they would have to be there. Obamacare rules have been something that has been also looked. This is a mixture of both religion and freedom of speech, but where some of the rules that Obamacare has, that where companies that are forced to do for health care. Best example of this will probably be for Hobby Lobby, where they have been able to sue and not have to do some of the things that were in the Obamacare rules there. One thing that has been happening a lot here in the recent decades have been judicial activism by conservative judges. Normally you think of judicial activism with liberals, but this is where we have had a lot more conservative judges that have overturned past rulings of lower courts, or have overturned what was voted by the people or by the state legislature. So that is what deems as making policy and the activism that we have here. All right, second part of the First Amendment we have is freedom of the press. This is something that's been seen as deep into our U.S. history. Even before we were a country, we had the Peter Singer trial, where he was arrested for criticizing the British royal governor, and ultimately the jury said that, well, no, he's able to do that. That we have. Colonial newspapers were also very powerful, and this is where you kind of think about Ben Franklin in the past. One of the cases that you got to know was the idea of censorship and prior restraint, the New York Times versus the U.S., going back to the Vietnam era with the Pentagon Papers here. And what prior restraint was is that they can prevent material from being published, but this is where for the New York Times it had already happened. A lot of times this is where we look at things, and what government will say can't be done is because of national security, which Neer versus Minnesota does give that as a reason that they have. But how much is national security in here? And that built upon the Schnick case, which was the clear and present danger doctrine that you have. So again, later on, this is where Schnick, where we have both for both press in this case and the freedom of speech that you have. One term that you do need to know the difference of, and a lot of times I just assume that my students know, but make sure you know what the difference is between libel and slander. Okay, slander being spoken, libel is something that is written. Social media, it's loosely but still considered part of libel that you have. A court case that you don't have to know off the top of your head, but one thing that you do have to know is New York Times versus Sullivan. Which pretty much says if you are an elected official, you're an open case there, and you basically you're able to be what you might think was slander that you have, unless it can be proven that there was true intentional malice there. You're pretty much fair game if you are an elected official. This has been questioned a lot lately, mainly because of fake news, and I mean true fake news, when we have deep fakes and things like that what is being done in that case. Another thing we have for libel and slander is where different presidents that have used the idea of executive privilege. President Clinton was trying to say that his lawsuit and Jones versus Clinton that shouldn't be heard while he's president. When Trump was president, we had a lot of court cases that he was saying that shouldn't be. Most of those he was able to delay, but the courts usually said, no, even though you're president, you're not above the law in that case that you have. Going back to our bureaucracy side, remember the FTC and the FCC that are doing things for truth in advertising and commercial speech and regulating that. Another part that you have in our textbook that is more for the reading, but with shield laws, where the idea for the freedom of the press and the idea that they are able to protect their sources. But on the other side, there's also then where we also have it for getting certain warrants. The police also use shield laws for what they have. All right, third part of the First Amendment is the freedom of assembly. Once again, it's going to be broken into two parts. We have the literal right to assemble in this case in here. So you are getting together to make a statement. You have the right to parade, protest, picket, demonstrate. Now, there are certain limits that can be made. Two cases you have to be familiar with, and here are the Stokey and Westboro Baptist cases. For the Stokey case, this is where in Stokey, Illinois, the neo-Nazis were wanting to do a parade and when they were filed to the town to do the parade, the town was saying they were going to have this incredibly high amount insurance policy. They sued, and the Supreme Court had ruled that they cannot do that unless there's a case that you have it that you're equal to everybody. So if you did it for the neo-Nazis, you still had to have that same regulation if the VFW was doing a parade. Westboro Baptist, this is where we had the Reverend Phelps, who got famous first of all by going against like black businesses, or not black businesses, but gay businesses in Topeka, Kansas. He then came onto the national stage where he would be doing protests and outside of inaugurations. But where the court case came was where he started protesting outside of soldiers' funerals during the Gulf War. And he and his followers would be across the street, but on public land there, and they would be protesting and saying the reason why the soldier died is the fact that, and you see some of those signs in the picture there, that God was punishing the United States for accepting homosexuality. When that made it to the Supreme Court, once again, they said that they have the right to do that. Despicable speech is still protected speech. And so that's why for both Stokely and Westboro Baptist, and that's where I was saying about earlier, that if you are a member of the KKK, you can give speeches for that side, as long as you are not inciting violence in this fighting words that you have in here. So you have to look at the time, place, the manner that things are done here. The second part of the right of assembly is the literal right to associate with other groups that you have, or not the non-literal right that you have in here, where you can come together even if you're not physically together. The ideas that we have today with interest groups and political parties. So I am allowed to join the NRA or PETA or be part of the Republican Party or the Communist Party or Libertarian Party. So you have those rights to join in together here. One court case that just to be familiar with, and this is where the state of Alabama, when they were trying to find who were members of the NAACP, they do not have to always reveal who their membership are. There are certain instances that they do have to, but they don't have to just tell who their religion, who they are. All right, our fourth part for this is religion. This is one that the College Board will go the deepest into. Please read this part for the First Amendment. The words, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Then we get to the rest of it. This is extremely important that you know. That first part is the Establishment Clause. The second part is the Free Exercise Clause. Also notice there is no direct words of separation of church and state. That is one of our penumbras. We do have some original intent where we have letters from Thomas Jefferson where he states about, I believe it's the Danbury Church letter, that's the idea of separation of church and state. But that is where the Establishment Clause comes in. Now, there's not to be any established religion or official religion. Many of our founding fathers were religious, but they wanted their religion or their denomination. So you had Congregationalists and Puritans in New England, Quakers in Pennsylvania. We had people from the Anglican Church in Virginia. They wanted their church to be the official religion, but did not want anyone else to be. So that's where the Establishment Clause comes in here. The problem is this is where, how much is it that we can mix with church and state in here. Recent years, this debate has come up more in a lot of things in schools. So funding by private schools and school prayer for what you have in here. One of our court cases that you have to remember was the Lemon case. And remember, we had the Lemon test. This had to deal with money that is going to religious schools. The key thing about it for the Lemon test, if we're going to make it overly simple here, is the money is supposed to be used for a secular use that you have here. Also, this is another case that we have that you can use vouchers for tuition. So here locally, if we were deemed an F school, there you would be able to get vouchers to go to Trinity Catholic or Seven Rivers Presbyterian school, and so state money can be used for that. Another one of the cases that we had in your cases was the Engel case. This is where they established that school prayer was not allowed. Now, you are allowed to pray in school. It just is not to be government mandated there. So You personally can say a prayer, and there can be student-led prayer, but there cannot be me as a teacher or an administrator or someone like that. That is the one that is leading it. We will also have cases that will expand that to moments of silence. Now, we can have a moment of silence like we had one at 9/11, but we can't have one every day at the same time. The same thing was true with court cases saying for daily Bible verses that you have. So this is where for the Engel case, which as when we were going to court cases, that was one case in the history of the United States that the majority of people disapproved of what the Supreme Court say. So where I say, can a student lead a prayer at school according to Engel? Yes. Okay, and a couple of weeks from now, when you go to take your AP exam, all right, you all can get together. You can pray. You can pray individually. You can have a student lead prayer. I cannot do that. Okay, I am not to be with that side of this. This is an older thing, but this is where it actually, Rutherford B. Hayes, who was one of our most religious presidents that we had, and this is where, I mean, I always say this is a pretty wise quote for what he had about how government shouldn't interfere with religion, but that it should be the other way around also. And for some of you, a more recent meme that you have in here. And I was talking about how if I was to say to you all, okay, we're going to have a prayer every morning at 9:30, some of your parents would be like, it's about time. But how many would appreciate it if I said, okay, we're going to turn to the east and bow to Mecca, with some of these same parents that were saying it's great to have the prayer, would they support that in here? For government, for public displays, where we looked at the County of Allegheny versus ACLU, and this is dealing with different religious symbols like nativity scenes that we have. And if you remember with this case, it was kind of confusing, but you are allowed to have things as long as it is opened up to everything. So you cannot have it where one religion is over the other. And I gave the example of the Florida State House, where they put a nativity scene up, and then another one put a menorah, and then we had a Festivus pole that was put up, and we had a person that brought a statue for the Church of Satan. So again, all of these things, if you open one up, you have it. I say down here, what about Christmas trees? And when we were discussing this case, Christmas trees were deemed as secular there. Yes, it may. And even they don't have to be called holiday trees either, because again, Christmas is both a religious as well as a secular holiday in here. What about the Ten Commandments? This is where they can be in certain public places, but you also have to allow again other religions. Most places won't allow that for what you have. But one reason why the Ten Commandments is a little bit different is it's not just Christianity, because Judaism and Islam use the Ten Commandments, and most every religion has some sort of set of rules of you should not kill, and you should not lie, and you should not commit adultery. So this is where the overall idea is, but again, this is where by itself is the difference. All right, so that was the Establishment Clause. The other side now is the Free Exercise Clause. The First Amendment also protects your right to practice or not practice any religion, and that's the Free Exercise Clause. Now, I summarize a lot of things in here, but the Free Exercise Clause says the government can't infringe on your beliefs, but it can regulate it to a certain extent. They can't ban practices in there unless they do come in conflict with other laws in there, but they can't forbid the worship itself. So this is where you have the course of rule. People have the right to believe whatever they want, but there can be limited to the practice here. And this is where our court cases will look at this. So you cannot do any and everything that you want to just because in the name of religion in here. So the courts have said where some religions said that we can have polygamy. The courts have said no, you can. And this is where when we look at the Church of Latter-day Saints or the Mormon Church, where they outlawed it in their church and said that you can't, even though I know there are sects on it. Blue laws, where there are some areas, communities can have things. It used to be in Crystal River that they were not allowed to sell alcohol before noon on Sunday. That's a blue law that you have. So yes, you are allowed to have that. We can be a dry county if we wanted to. They could vote and have that side of it, or say that we're not going to sell alcohol or have things open on certain days. They can do some regulations like that. Big case you're going to have to know, that's on the next slide here, is where it comes for the children being taken out of the school. But Jehovah's Witness students, state of Florida, you have to stand, but you do not have to salute or say the Pledge of Allegiance in there. And then alcohol and drugs used as sacraments How many of you have been, if you're in a Catholic church and you had a priest give you wine? Okay, you're underage. So they can do it as part of the sacrament. Now, you can't go to Ruby Tuesdays afterwards and split a bottle of wine with your priest in here. A couple of cases that kind of look at it and see what the difference is for this. In Oregon, this is where an Indian tribe had sued, saying that they used peyote. And what they said that they could trace back, back centuries to where this was a religious practice. Meanwhile, in South Florida, we will have a Rastafarian church that will sue and say that marijuana was part of their practices. And what the difference was is, yes, Rastafarian had been around for a long time, but the use of marijuana wasn't that long. And so, no, you couldn't use religious as a reason to use that side of it. Now, Wisconsin versus Yoder is one of the cases the College Board says you have to know. And this is where we have a conflict between government and then the religious rights that you have. What happened was the courts ruled that you could not force students to go to school after 8th grade for religious reasons. Now, one thing that made the Amish different than some other groups is the Amish could prove that they were not a burden on society. Their children, even with an 8th grade education, were self-sufficient. They were not using welfare programs and that. So that is why they were able to. Not every group can do that so just as you're out in here. This is a generalized question that we have, but you think about, especially since 9/11, where we have the issue of security. But you see this woman who part of her religious practices is to cover as much of her face. Has not been as much here in the United States as in France, but some issues, like if she was to go get a driver's license, in most states she would have to show her face in that case. So this is where the free exercise clauses come into conflict with security. All right, our fifth and last part is the freedom of petition here. No, it is not. You're writing a petition saying you want to have tater tots at lunch. Petition is a grievance to the government. So you are allowed to criticize your government. You kind of can mix in this, and this is both a mixture of freedom of speech and freedom of press. But you can write a letter. You can write a letter to the governor of Florida and criticize, or write a letter to the editor. You are allowed to have this for grievances, and that's where the right of petition comes into things. You will notice here for court cases that there's a lot of court cases listed on it. Now, the College Board now has it where there's certain court cases you have to know. In the past, there were some they assumed you know, but then a lot of times what they would do is they would put what the topic is. So this is where I had in the notes about polygamy, and I had about the Oregon case. I did not have the Reynolds case in here, but I spoke about how the states were able to regulate the religion in this case. But this case here, for the Indians, they were allowed to use this. So that is where sometimes they have this for the issue. Yes, there are some cases you have to know straight off your head but a lot of these is where they'll give you. I have the 36 cases. If you look at different study guides, I've seen some with over 100 cases of one saying. I think that's a little bit of an overkill, but this is where the broad ideas that you have to do and things. Our next section will have the rest of the amendments.